Do you enjoy the harvest of Missouri through food, fuel, or fiber? Interested in strengthening your community or making a difference in the lives of others? You're in the right place. This is Stand for Ag with Missouri Farmers Care. Join us for thoughtful conversations around the intersections of farmer, rancher, and consumer interests. Grab a seat, press play, and join the conversation.
Welcome back to another episode of Stand for Ag. I'm your host, Taylor Vollen, and I'm joined by Brent Haden of the law firm of Haden and Colbert. If you haven't yet heard about the Cooper County farmers that fought back against their local health board's efforts to regulate concentrated animal feeding operations, this is an episode you are not going to want to miss. We're going to be discussing the ins and outs of the entire legal battle. But let's start off, Brent. Just tell us a little bit about yourself and your background.
Yeah, so I am an attorney in Columbia, Missouri. I've got a firm there, and we've got 6 attorneys in our firm. It's my wife and I are partners, and then Caleb Colbert, this guy from Bowling Green, and then we have Caden Guyman and Kate Bush and Kelly Joyce, our other lawyers. We concentrate much of our civil practice on agricultural issues. Probably 85 to 90% of my civil work is in that area. And of course, Connie does a lot of estate planning and things like that for farmers and ranchers as well. And Caleb, our other partner, has an ag background coming from Pike County. And so he'll do some mostly real estate issues, but he'll do ag property work as well. And my background, I grew up at Mexico, Missouri, actually almost to Avaz, but went to high school at Mexico. We were the last house in the district there, straddling the Audrain-Callaway line. And did my undergrad here at Mizzou and then law school at Harvard, and then got out off the East Coast as quick as possible and got back. We've been in Columbia since 2011 with our own practice. And really one of the big things, obviously, especially with the area we're talking about today, is environmental regulatory issues have become obviously a major challenge for agricultural producers. And we concentrate a lot of our practice in that area, along with some other just issues that arise for producers all the time. But governmental compliance and environmental compliance is obviously a significant issue for producers and something we do a lot of work on.
Right. So really, we're going to be focusing on one case today. And it's really kind of a big win for farmers in Cooper County that fought back against, what would you say, for lack of better words, some out of control government regulations.
Yes.
Kind of just give us a background on what really happened.
So I got to think all the way back. It's 2018 is when all this kind of started to go down. In early 2018, there was a proposal to put a confined hog operation in near Tipton. It's what a lot of people call the Tipton East Project. Before, Cooper County before that already had some permitted confined operations in it that apparently came as news to some of the health bureaucrats in the county, because once the new project was proposed, they started to go a little bit nuts about trying to keep livestock out of the county, and apparently didn't know that they already had it in their county. But that's where it started in 2018. All that spring of 2018 and into the early summer, there was wrangling about a potential regulation. Obviously, farmers and ranchers in that county had major opposition to a regulation going in. And the regulation, it was twofold. I mean, a lot of it was a regurgitation of what had already happened in a lot of the counties north of 36, going all the way back to the mid-90s. I mean, the original regulation they were proposing was essentially modeled on the Lynn County regulation going back to the mid-90s. But they also were going to put some other twists in terms of regulations on spreading of manure and litter. This is a part of the world in kind of Cooper and Montauk County, particularly Montauk, but even in Cooper County, there are a fair number of commercial poultry operations, a lot of turkey operations. And so, litter is a good economical local source of nutrient that a lot of farmers utilize. And so, there was obviously concern about that, along with just the regulations on being able to raise the livestock anyway. And it was really great to see here. I mean, sometimes in the past, and I think this is getting better, but in the past we've had trouble where livestock producers and crop producers, if you do one or the other exclusively, they don't always work together politically the way they need to.
Right.
we're starting to get smarter about that. This issue really, because I think in part because it did touch all pieces. I mean, they were trying to create strictures on the livestock operations themselves, but also on the use of manure as a good, relatively cheap, locally available fertilizer. Really brought crop and livestock operators together to oppose the regulation. They also, as the spring of 2018 progressed, I mean, there were some interesting things that happened. The health board went and visited several facilities and looked around and kind of, found out they had more of this in their county than they realized. And I should say a bit about this health board. In the past, in some places where we've had these fights, it's been with the county commission. The Cooper County Commission has actually been great. I mean, they were great. They are now, they were then. I mean, they've never been on board with regulation or opposed to livestock. They've been strongly in favor. Cooper County is an agri-ready county under Missouri Farmers Cares, under their stamp of approval for agri-ready things, and in part because the commission has always been so good in terms of where they want to be. Cooper County, though, has an independent health center board of trustees. And there's a split in how this is done in Missouri. Some counties, your local health department will still be under the control of your county commission and funded by the county commission. But since the 90s, it's been available as an option for these health centers to also spin out, and really the commission has to do it initially, but to spin out these health centers into their own independent boards with their own independent and separate tax levy. So their own independent source of funding, and to where those are independently elected boards and that have autonomy away from that county commission. So in some places, if your health center starts to get too far out on the ledge compared to what the county commission wants, county commission has authority over the executive director and can make hire and fire decisions. But in Cooper County, that wasn't the case. In some other counties, that's how it is in Missouri. It just depends on whether that's what your county did. But in Cooper, they did that and had spun this out into its own independent board. So there were 5 members of that board that were independently elected. And then they had an executive, or it has an executive nurse that runs the center. And so, there was, and really what we had in the spring of 18, you had board of trustee members that early on appeared to be kind of reluctant and all over the board in terms of what they thought about a regulation. But you had a nurse at the center there that was their executive director. She was very, very aggressive in advocating for a regulation. She clearly wanted one. She was vocal at their meetings, some of which I attended, the public meetings. I think anytime, what I observed is anytime that the trustees would start to kind of soften or move away from possibly passing a regulation, she would bring them right back around in those meetings and speak up and try to refocus the conversation on making sure a regulation happened. That was extremely frustrating for our farmer ranchers that I was working with in the county, because it seemed to be a little bit of the tail wagging the dog. So rather than trustees making this decision on how this was going to move forward, it was a professional bureaucrat employee telling them how it was going to be.
This podcast is brought to you by Missouri soybean farmers and their checkoff. The Missouri Soybean Merchandising Council is a farmer-run organization dedicated to improving the profitability of the Missouri soybean farmer through a combination of marketing, research, and commercialization programs. The checkoff is committed to empowering Missouri soybean farmers through innovation. The council is run by the farmer for the farmer, with 13 farmer leaders from across the Show Me State. To find out more, visit mosoy.org.
So as we moved into the summer of 2018, it became obvious that this board was probably going to be pushing towards a regulation. The opposition from farmers and ranchers was becoming, loud and insistent. I mean, they were very frustrated this was going to move forward. Those meetings were starting to have 100 people, 110, 120 people showing up. I mean, they were filling the basement over there at their public health center. They would cast these meetings as, oh, whether there's people here from both sides, and there were, but it was usually many farmer and ranchers and a few proponents of the regulation. I mean, you get what often happens, it seems like, in these, that they rely on the illusion of, well, there's voices from both sides, but don't really talk about actual numbers or intensity.
Right.
And so, and I mean, I think that was to their political detriment, but what they really had there was 4, 5, 6 voices that were very aggressively in favor of a regulation. Much of the angst over Tipton East appeared to be built around the gentleman who owned the property where the facility was going to be built, had a sister that was the next property over. I think there was maybe some old heartache there for other issues that were unrelated, but she became a very vocal advocate against building this facility. And so she was normally coming to these meetings, along with, there was a doctor there in town, I believe, that had a strong opinion about it. The group I worked with really began to push back and did a great job of coming to those meetings and voicing their concerns. At one point, there was a regulation proposed that had these really aggressive setback distances. It was going to be where you couldn't have a facility within a certain number of feet of any dwelling or any building, and on down the list. We were able to make. I mean, you could take that regulation and make a map, which we did. We had a cartographer lay out a map for us that showed exactly what the county would look like in terms of where you could put a facility. And one of those proposals made it where you essentially almost nowhere, a very few places in the south of the county, there would be a couple places you could legally put a facility under that regulation. And that was going to be on some of the very best crop ground in the county. So in terms of, in a livestock operation, obviously the modern facility, ideally you want to put it somewhere that's less productive, but close to productive ground. It gives you a place to spread nutrient, but you don't want to eat up productive ground. And really they were down to where that was the only place, and otherwise there wasn't going to be anywhere. So as part of that, as we moved into July and August, the board was becoming, we think, less transparent. It was becoming more defensive in its approach. Several of my clients sent sunshine requests to the board in early August of 2018, requesting various items of information because they wanted to try to figure out what was going on. One of the most galling things to them is at that point there was a opposition group to the Tipton East project that had already sued to try to prevent that permit from moving forward. I wasn't involved in any of that litigation, but that was going on. There was a belief that the attorney, Stephen Jeffrey, who was working for the opposition group in that lawsuit, was also potentially involved with or doing work for the health board. Mm-hmm. And that was one of the requests that was sent from one of our clients, requesting they wanted to see the invoices, which is an item you can get in sunshine law from attorneys they were working with. And the executive at the health board, who is also the custodian of records, she refused to turn that over. Sent back a letter just saying, we're not going to turn that over. They cited to what a supposed attorney-client provision. Well, not even an attorney-client provision, but there's provision in sunshine law says you don't have to turn over documents relating to legal matters, but there have been longstanding case law that says an invoice like that sort of document is something you do have to turn over. As we got into August of 2018, it became pretty obvious to me they probably were going to pass a regulation. Our guys wanted to see, one of the things they wanted to see was a draft as we went, and there were no drafts, just weren't being produced. Mm-hmm. We now know from discovering our suit that there were drafts flying back and forth between members of the board of trustees and Melanie Hutton, who's the director of the health center. She was working on those drafts and was involved in that process, and they knew she was. So on August 24th of 2018, they basically, they went in and they had a closed session that day at the beginning of a meeting, and they came into open session read the regulation. It's the first time any of us had actually heard the regulation they proposed to pass that day, and passed it. And that was called Regulation 5. So after that passed, the next month, we filed suit on behalf of, I think originally we had about 103 farmers in our plaintiff group. Numbers moved a little bit because unfortunately this has gone on now enough, and over the top of a pandemic, we've had a couple of the members of our panel or of our crew of plaintiffs that passed away, and so the number's a little movable. But I think it was 103 when we started, and they all want to be. You know, a lot of times at this, you'll get a named opposition group like citizens of whatever county or whatever. But our clients felt like it was important to go on the line in their individual capacities here, because too often it's easy to make these like faceless sort of advocacy groups, or that's the temptation for outsiders to see them as faceless advocacy groups. These were 103 people that were all involved in farming and ranching in Cooper County, and they felt very strongly about the way that this regulation was going to affect their livelihood.
Right.
And the biggest immediate issue was not just the way it would affect, as I said earlier, permitted livestock operations from going into being or being built, but also the way that it would really, control and, deeply affect and even sometimes prevent them from using manure and litter as a nutrient. And that's obviously a very important thing for these guys in terms of economic fertility practices. So we brought that suit, and originally what we brought the suit for, and this has sort of been the thread throughout, and there's been some changes, but originally we brought that suit, we filed and said that, look, you don't have good science for the basis of what you're doing. And so what you're doing is what we call arbitrary and capricious. You'll hear that term all the time in legal circles. That's because that's the test for overturning a regulation where you don't believe there's a good basis for passing it. So we said, your regulation's arbitrary and capricious. It's not based on sound science. It makes these weird artificial distinctions between manure and synthetic fertilizer, for example. It makes weird artificial distinctions between manure from a CAFO versus any other kind of manure. Like it didn't affect, and I'm fine with this either way. I think it's all great, but it didn't, for example, if you just picked up manure out of a standard cow-calf operation out of that lot and went and spread it, you could do whatever you wanted. But if you picked it up out of a confined operation that met their definitions, you couldn't, even though it's all the same manure.
Right.
And so it just made it had a lot of irrational distinctions. And that's exactly the point that always happens with so many of these kind of regulations. And I've seen it, I've practiced a lot in Missouri and in Kansas, and we've seen it in both states and seen it all over the US. So many times when these regulations come in, it's about who it is, not what it is. They're going after the person. They don't like something about the person or what they're going to do rather than really the practice.
Yeah.
I think that's kind of how this one started, and then mushroomed into this, like, oh, well, we have a principal position about the practice as well. But you still see these really kind of irrational distinctions that don't, even if they believed their own, what we think is nonsense about this being a health risk, you wouldn't have written the regulation this way. If you really believe that spreading manure is going to kill you, which of course is preposterous, but let's say you assume that's true, well, then you'd make the regulation on all manure, not just on confined manure. If you, and there also were, the other regulations they put in that were really troubling is they put in regulations on ammonia and hydrogen sulfide and on particulate matter that were based on CDC regulatory thresholds from the 70s, but that are not even set up for what they are purporting that they're used for. So let me explain what I mean on that. So for example, for ammonia, they had a regulation that was you had to be under 1 part per million in terms of ammonia at the edge of your property. Most studies will say that most people can't smell ammonia below 20 parts per million. The most sensitive smellers may not be able to smell it below 5 or 6 parts per million. And they wanted to go below 1 part per million. And all that to say, in open air, those thresholds are not you'll smell ammonia long before it's dangerous to you in an open air setting. So it's not even to say it's dangerous. That's even if all you're talking about is potentially annoying. And but what the CDC reg that was set below that number when you read the actual CDC literature, and it's the same thing for hydrogen sulfide and particulate matter, what they say is, we're not saying that a number above this threshold is unsafe. We're saying for like, this was kind of given as guidance for like municipal nuisance investigators and things like that. What they're saying, when you go to, CDC is saying, when you go to a site, if it's below this number, we feel certain there is no risk to human health. You can just go on down the road. Like, but we're not saying that we've actually explored or know if there's what the safe number is above that.
Yeah.
But they took that number to then be like a safe threshold. In ammonia, one of the problems, for example, is that especially in spring and fall, when you've got planting and harvest going on, you're turning soil over. Ammonia kicks out naturally through all sorts of just crop farming processes. There was a study from Ontario, which has less crop farming than we do in the Corn Belt here, that said in spring and fall, that you would see natural ammonia concentrations of, for example, 3 parts per million, no matter what was going on. So this regulation from Cooper County would say you have to be below one, it was even less than 1 part per million, but it was below 1 part per million at the edge of your property. And nobody else has to do that. No other kind of farming or industrial operation has to do it.
Yeah.
They're the only ones that have to do it. And it may actually be literally impossible to do that to begin with if you have ambient air in the 3 and 4 parts per million just from normal farming activities. So that's a great example of what we're talking about. We said the science, it wasn't just that, oh, we don't like the regulation. The science doesn't make any sense. And it's what often happens with this. They're trying to convince people that really what it is a practice they don't like. Confined operations are practice they don't like for all sorts of social and economic reasons, potentially. That's fine. That's one debate. I mean, I'm happy to have that debate. But whatever you think about that debate, it's not honest to tell people these operations are killing you to try to win that debate.
Right,
and that's what they're doing. It's the same debate we see sometimes with organic food and other things. This is America. People can do whatever they want. It's my position as far as, organic food or any of that. But it's not honest to tell people that conventionally raised food is killing them when really what you have is just a social complaint or an economic complaint. And you really need to have the social and economic debate. Don't make up the science. And it's the same thing here. So those are part of our claims. And the other part of our claim in this suit was that they just violated the Sunshine Law. And they did that by having, there were open meetings they didn't properly notice. There were closed meetings that weren't properly noticed or closed. Both of those have requirements in the law. And then that they improperly refused to produce attorney invoices. And our plaintiff, Brian Cleathermus, is the guy that sent the letter here on that. In response to his letter, they improperly refused to send us the invoices so that they could know what was going on with the attorneys. And remember, that's important because this is a taxpayer funded entity. So they're really only asking to know what was being done with their tax dollars. They're not getting into the business of a private party. So that suit was filed spring of 18. We also got very early on in the case, asked for and received injunctive relief in the case. The judge said, look, nobody can enforce this until we figure out the suit. And so we at least got our guys some relief where they could continue to farm as normal. And that was all cast against the backdrop then in the spring of 19, when the ag groups in this state did an amazing job of getting a push on for Senate Bill 391. Senate Bill 391, and this really was a team effort from all the agricultural groups in the state, got together, pushed hard, really, it was a tough slog and got this done through late night sessions and all the other things it takes now to get something through the Missouri Senate. And 391 came back and said, okay, that bill took away the statutory authority of these health centers to regulate agricultural operations. So kind of the quick and boring legal history on this was in the early 90s, a law went into effect that banned class 3 counties, that's small rural counties, from zoning agriculture. They said, okay, if you're a class 3 county, which most rural agricultural counties are, if you're a class 3 county, you can't zone agriculture. You just have to leave it alone. And most counties were fine with that. Most counties hadn't tried that. But when that tool went out the door for the counties that did want to try to go after conventional livestock, modern livestock operations, their new approach was to say, okay, well, we're going to pass a health reg instead, because Chapter 192 of Missouri statutes had given these counties and also health boards, if they were spun out independently, gave them the authority to pass laws dealing with human health. Now, it was only supposed, if you read that statute, it's really only supposed to be for, it looks like the intent of the legislature to me was probably for communicable disease.
Mhm.
But they've taken that a much broader warrant from that and said, well, any disease or anything that affects human health, which there's almost nothing in the world that you can't make some argument affects human health, by the way. But that was the statute they're using to regulate. In the mid-90s, there was a challenge to the Lynn County statute. They said, I'm sorry, the Lynn County ordinance, they had a local health ordinance against conventional livestock operation. And the claim there had been in that claim from the producers in that case, they said, look, you can't make regs above and beyond state law. You've already preempted it. And really the way this works is it's a complex, pass down of federal law. The federal EPA acts, I mean, all these environmental acts deal with clean air, clean water, et cetera. All those are then the authority on that is delegated to the states to enforce. And so it's federal law being enforced by state inspectors and state regulators. So in Missouri, that's DNR, Department of Natural Resources. They go out, they do all the inspections and enforce that law. The county in the Lynn County case, much like what they try to do here in Cooper, they were piling on then an extra set of regulations that went above and beyond even the DNR reg. And the courts in 95 had said, or I'm sorry, this case started in 95. I believe that's a 98 case. I don't have it in front of me. It's a Fahrencop case. Court there came back and said, look, you can do that. That's okay. And so since the mid to late 90s, we've been dealing with this issue where local governments are able to make regulations that surpass state government. And it was creating this patchwork quilt effect where one county you could operate, in another county you couldn't. And this had already been an issue, which for agriculture that was a problem. But the resurgence in Cooper County and some other places of this approach, I think finally led, us that advocate for agriculture say is enough is enough. I mean, you'll put everybody in the state out of business slowly by patchwork. A similar thing had happened about that same time in Cedar County, Missouri, down in southern Missouri. So, that in 391 was a bill that came back and said, okay, well, just like we did with zoning, I mean, it doesn't say that in the bill, but this is essentially the same analog. Just like we said in zoning, you can't zone out agriculture. And we're going to say the same thing to health boards and county commissions. You can't use health regs to put agriculture out of business if, and it basically said if it's inconsistent with or more stringent than all these other chapters in state law. If you're doing something that's more aggressive than or inconsistent with state law, then you can't do it. And that passed in the spring of 19. I think in part in response to that, as a consequence of that, then in June of 2019, the Cooper County Board of Trustees for their health center came back and rescinded their Regulation 5. They got rid of it. Well, that seemed like a good thing, except that they then turned right back around in August. And on about 25 hours notice, I mean, Missouri, a local government only has to give you 24 hours notice, but we didn't know it was coming. It's like we were actually all up at the state fair. I remember when we got the kind of found out that on short notice, legal but short, they turned around and then passed a new reg, what they called Regulation 6. And ultimately, we had all the same problems with it. I mean, the provisions were just not acceptable. And so we amended our lawsuit on behalf of these same plaintiffs. But we amended in now a new claim that after the passage of 391, that it's not just that it's bad science, it's also that you just can't do this at all. You don't have the regulatory authority to do that. And it's taken 4 years on this, in part because then COVID interposed itself and everything in the courts really slowed down for a good long while. But we were able eventually to obtain a summary judgment from the court as to what we call our count one, that basically said, no, they don't have the authority to do this, with the exception of one thing. The court originally, in the first go around of summary judgment, said, well, they can maintain an ammonia reg because even though there's no reg on that, and maybe specifically because there's no reg on that, the federal government doesn't have thresholds on ammonia. Other than, I mean, there's some OSHA regulations on ammonia in indoor spaces, but in terms of ambient air, outdoor air, agricultural ammonia, there's no regulation on that. court there ruled that because there was no regulation, then you necessarily can't have a regulation that's more stringent than or inconsistent with a non-existent regulation. Now, and partly, to be fair to the court, they were kind of pointing back to a case from 2003, which they held something similar, and what I also think was some pretty tortured reasoning. But in 2003, there'd been a suit in Missouri. Missouri passed then and still has a law that says the state is not going to pass any environmental regulation that's more stringent than the federal government puts on you. And there was a substance, I can't even remember what it was, which it may have been hydrogen sulfide. I can't remember honestly which substance it was. But the feds had declined to regulate. They said in part because they thought states were regulating it. Well, by Missouri law, then that means we shouldn't have had a regulation either. But the court said, well, if Missouri wants to, if this is DNR at the time, tried to promulgate a regulation. The court said, well, if DNR wants to regulate it, we think they can here because that's not what the legislature meant. And so you can't have, and it was the same reason, you can't have essentially a regulation that's more stringent than a non-existent regulation. If it's non-existent, then it's basically all bets are off. You can do what you want. And I think looking at some of that reasoning, that's where the court went here. I mean, to me, given the language we passed in the Senate Bill 391 that says if it's inconsistent with or more stringent than these state laws, I mean, logically, I mean, it's the same thing if it says you can't have something more stringent than a state law, I don't know, if you can't, state law says you can't possess a shovel, or counties, I should say, says you can't possess a shovel, but state law has no laws about shovels, then that's more stringent than state law.
Yeah, absolutely.
But logically, that's where we were. But because of some past precedent that also was problematic, but still the law, that's where we ended up. So bottom line is we got a summary judgment determination on everything except ammonia. And that was in the fall of 20. Mm-hmm. So in the spring of 21, the legislature came back in and passed what they called Senate Bill 271. It added a little bit more language to the underlying 391 language. And it says, now you also can't have regulations that are different than or in addition to state law. So it says more stringent than, inconsistent with, different than, or in addition to. If it's any of those four things, I think that covers every base. And we went back and asked the judge for a follow-up summary judgment on that basis. And in the spring of 22, we were given summary judgment on that. So my clients, the 103 approximately plaintiffs that we represent, have received summary judgment on our count one now. And that's where we've been since the spring, where the judge just said, hey, you can't make this regulation under state law. Now the legislature empowered the health board originally. I mean, that's who gives them their authority. And now the legislature's taken a piece of that away to say you can't make that kind of regulation through a local health board. That left us with, well, let me tell you first, that left us with sunshine issues, and I can come back to that. But I know this is a complex and exciting tale of legal maneuvering. Should be noted at the same time all this is going on, that the health board Cooper County Health Board had joined the Cedar County Commission, who passed a regulation at the commission level, in a lawsuit against the state that my clients are not parties to. But at the same time, our suit's been going on. They sued the state to say that the state doesn't have the authority to either pass 391 and 271, or at the very least to enforce it retroactively back against the county regulation. So, and their arguments there have been complicated and at times I think absurd. I mean, one of their arguments was that it violates the state right to farm constitutional amendment that was passed in 2014. And this one's really puzzled me because in 2014, the amendment we passed, and lots of I was involved, the ag groups were involved, everybody was involved in trying to get that thing done. It says the state cannot regulate out farm and ranch practices, and then left for the locals the authority to do it under any constitutional Article 6 authority they have. but if any, it doesn't say specifically what that is, it just says if they have it under Article 6, then they get to do it. Well, first of all, county health boards don't exist constitutionally at all. County commissions do, but then the Constitution also says that they're only empowered to do what they're empowered to do. And the county health boards only exist completely at the action of the legislature. I mean, the legislature set up in chapter 205 of the state statutes how these boards can exist, and then they empowered them in chapter 192 as to how they can act and what their authority is. So they are completely children of the legislature for these health boards. And so logically, the legislature ought to be able to take back whatever authority they've given, because they've decided, that's not your authority now. But their constitutional argument, it's roughly equivalent to, it'd be like if you argued, well, the federal government can't tell you what religion to be, so that means they also can't stop states from telling you what religion to be. This doesn't make any sense. I mean, here they're basically saying the state is forbidden from making those kind of rules, so they're also forbidden from telling locals that they can't make rules like that. I'm still flummoxed by it myself. I don't really understand the argument.
Yeah.
The other thing they've argued is just that these rules can't be applied retroactively. I mean, the new laws can't be applied retroactively. So they're saying if our rules were already in place, we get to have them forever. And that just, I think, goes against the weight of the case law that we've seen over the last 20 years, where it's been more the opposite way. It's that local regs go out the door unless they're specifically grandfathered in. And that's only what the legislature has done. So, but they're litigating that issue against the state. Of course, the state is represented by the Attorney General's office. The state has won summary judgment on that matter, where the courts just say, yeah, this is a matter of law. It doesn't have to go to a jury or anything. This is where we're at. And now that case, because they have anytime you challenge the state, on a statutory constitutional basis, the state has fast track authority to go straight to the Supreme Court without going through a court of appeals. That case is up for argument in front of the Supreme Court on September 20. So there's a lot that's going to happen on this fall on these cases. And that's one of the kind of milestones coming up here. On September 20, they're going to argue that case in front of the Supreme Court. Meanwhile, in our case, we still had sunshine counts remaining in place in the spring of 2022. The court gave us summary judgment as to the main issue. And so just here at the end of August, we tried the sunshine counts in our case. The jury came back in favor of our clients as to all 5 counts by making a knowingly finding. And so that means that they found that there were violations that were done knowingly by the health board. That's important because it potentially opens the board to, at the judge's discretion, an award of attorney's fees. And my clients plan to pursue attorney's fees. Obviously, they've been put through a lot here. But that's kind of where we're at with our case now. I mean, the jury has found in their favor. My clients have won us to the main underlying issue. We're about ready to move towards final judgment in this case. And then at that point at the district, at the district court level, the case is over. And it may be up to the other side to decide if they're going to appeal or not. I don't know what they'll do. They haven't shown much hesitation to run through tax money to fight this, even though I think that's been ill-advised in the beginning. Well, just like we think the regulation's been ill-advised in the beginning. But that's where we are.
Farming is a proud and chosen profession inspired through generations, tested, resilient, pushing boundaries of what's possible with every bushel while replenishing every precious resource, like the reduction of soil loss by 40% with every acre grown. I'm Jay Schutte, a corn farmer from Benton City, Missouri. At a time when growing more with less matters, there is no greater resource than the American corn farmer.
This message brought to you by Missouri Farmers Care and Missouri Corn Growers. Join the conversation on Facebook and Twitter.
So now, why is it so important that these types of things are left to a state matter rather than a county by county making their decisions on what they want?
That's a great question. And because a lot of times you'll hear people kind of carry on about local control and how important it is. And sometimes it is. I'm personally of the belief that local entities oftentimes, in terms of distributing money in the situation where you're trying to figure out, if you're going to fund something, but how do you spend the money? Local entities and locally controlled entities are often very good at that. and better than state or federal entities because they're on the ground and can target money in a more efficient way. When you talk about the regulatory state, though, that's a little different. So, you're talking about spending money that's like school boards or whatever the case may be. That's spending money and the government doing something for somebody.
Yeah.
When we start talking about regulation, what the government's going to do to somebody or the government's going to tell somebody they can't do, as opposed to them funding, you get into this problem where a couple different issues can arise with local entities. And that certainly, I think, is what's happened with what's going on with attempts to regulate livestock operations. One is that the potential for locally particular forms of discrimination against a given individual go way up. So when you have broad sort of state-based policies, it's very hard, and then generally are not targeted for or against one given person, one given man or woman or their operation or one given family or whatever the case may be. But you get into local politics, they, by virtue of their smallness and by virtue of the fact that everybody knows each other, that sort of motivation can really start to creep in.
Yeah.
And I think, and what I've seen over and over and over in the livestock operation context is that is exactly what happens. I worked on a case in Kansas when I worked for their livestock association where, hogs were going to come into a county, and this is the middle of nowhere in Western Kansas. There's plenty of space, and they had other operations in the county, but there was a local banker that wanted to do this. He was a relatively unpopular figure locally. And then suddenly now we can't do it. It's a bad idea. And and it was really about regulating that guy out of business. And so, however you're going to do it, the specific basis, whether we like a given person or not, should not form the basis of a regulation. That's not the law. That's personality starting to invade. And that's exactly the nature of being capricious or being arbitrary in lawmaking, is that you start to let personality drive it. And so that's one issue that we really need to try to avoid. And when you get to a broader state level regulation, that becomes much less of an issue. But it's also the regulatory certainty and patchwork quilt sort of nature of what they're doing. We want to make sure that there's regulatory certainty provides people the basis by which they can move ahead, because if you really want to see business move forward, then you've got, as anybody who's going to make an investment, particularly a large capital investment, this isn't just like buying, a used tractor that if it doesn't work out, it doesn't work out. I mean, even that stinks, but you're going to build big, hard facilities. Then you've got to have some certainty that for the life of that operation, at least the 25, 30, 35-year useful life of this building, the business you propose to carry on in there is going to remain legal. Nobody wants to throw money at something into a building that 3 to 5 years from now may be illegal, or that you just can't get built at all. And so, and you need that on a statewide basis so that you don't run into this problem where, you can run into this bizarre issue, and other states have done this, and it looks crazy where, 8 miles down the road is between two operations. It's completely illegal in one place and not illegal in the other. Well, why, do we really want to subject this isn't just in ag, this happens in other kinds of businesses, but it's particularly bad in ag. Is that really what we want? We want to have the basis be built around whether somebody's 8 miles from another place, even though it's the exact same activity. That seems absurd, and it's bad for the economy. It's certainly bad for farmers and ranchers, because it creates this weird hedge it's not really even anti-competitive. I don't know if that might be the reason they're doing it, but it makes it where farmer A can't do all the exact same things that farmer B can do, just as an accident of geography. And that certainly is bad for farming and ranching in Missouri. And it just makes it too difficult and too expensive to operate. Yeah. And it's a problem we see more broadly, I think, America in general over the last 25 years. One of the things people talk about, obviously, in the international stage, our ag industry is very competitive because we have plenty of it. We know what we're doing. But you see it you don't want it to happen like in ag, what happened in manufacturing, because a lot of people say, why do we lose our edge in manufacturing to a lot of the rest of the world? And expensive labor is one of the answers to that historically. But there's also the underlying question, well, why did it all become expensive? Why did everything become expensive? Well, one reason is everything became heavily regulated. Now you have to have lawyers and accountants and, you paying people like me money that you wouldn't have had to pay to begin with, had there not been a regulation.
Yeah.
And so overregulation, hyper-regulation, it's made it in some sectors that we just don't make things anymore because it's too hard. It's either too expensive or it's just illegal to make them. And you've got to think really hard about, that's why it's so important that you think hard about, do you want to do this? Does the science really support some finding of danger? And then even if it does, what's the cost benefit analysis as between the downsides and the upsides of what you're doing? It's not to say you can't have a debate about those, but so many times now we don't even think about that. Like we don't talk about actual risk balancing as opposed to just, a zero tolerance for risk. And we don't talk about the upsides that are lost sometimes when you overregulate. It's a long-winded answer, but I mean, that's the reason that to me, it is so important that, and you ask about local entities. I mean, sometimes there's this almost superstition that, well, local government is inherently better than federal or state government. And again, when you're talking about revenue and spending revenue, that may be true. But when you're talking about regulating, there's nothing magical that says local government can't also be overreaching and be, engaged in bad regulation, just like anything else. They can still regulate things they shouldn't regulate and get in the middle of things they have no business being in. They can still regulatorily overreach. Some of it's about the scope of their authority. And the problem you had here is that when you just give somebody this broad warrant that they're going to try to seize on, like, we'll let you just regulate anything that affects human health. There's almost no end to what they can regulate. And so we had a lot of different problems. I mean, that was one of the other problems here is that, frankly, the state legislature, when they empowered these local health boards and county commissions regarding health regulations, they gave them way too much authority to begin with as a matter of scope. Now, this is the legislature finally starting to bring some of this back and constrain that scope a little bit. I actually would expect there's going to be more of this and outside of the agricultural circle over the next 10 to 15 years. And we have this a lot in Missouri law. There's a lot of places, and I think this was the trend nationally coming out of World War II, where we empowered unelected bureaucrats to make these very broad and unaccountable decisions. I mean, obviously a lot of people found this out during COVID, that local health authorities and state level bureaucrats that you can't fire, not even in the next election, can, with the stroke of a pen, make a lot of rules that affect your life. And look, the legislature historically has empowered them to do that. I think we're now going to start to have a reckoning and hopefully going to start to constrain some of that. Ultimately, democratic decision makers ought to be should be the ones that have to make decisions that you have somebody to fire. And then there also should be just areas that they can't regulate. And this is the point of constitutions. And this is the point of putting rules in place that says like this far and no further for what they can regulate.
Yeah.
Go ahead.
And you can correct me if I'm wrong, agree, disagree, but what I think is so scary too is I feel like people forget just how easy it is for it to be kind of, it starts in one county, but that doesn't mean it's not going to happen in another. And how easy it is for counties to kind of say, well, this county did this, why can't we do it? And it's just as like a tumbling effect, I feel like, in some things.
No, that's we already saw that happen in Missouri, particularly north of 36 in the 90s. I mean, where you had this weird patchwork quilt of counties there, a lot of counties there. And the irony of that in Missouri in particular is that if you give them their due as to their environmental arguments, and I think some of those are dubious, I think some of those are very questionable, but if you take as true some of their arguments about soil types, et cetera, those are definitely the places we should be having those operations. Northern Missouri with thick, deep topsoil, a lot of crop operations that can use the nutrients. Those are the places we should have those operations in abundance. But there were historic, political, and social and economic reasons that's where the resistance came from. And no, you definitely saw that. You saw that whole swaths of the state up there made it illegal, but then other places didn't. And it gets to be very weird that with no other real difference in local conditions, you can do it in one place and you can't do it in another.
Switching gears kind of, now you have a background in agriculture, correct?
I do, yeah. I grew up, my dad was a veterinarian and worked for years for an FA, but grew up with a cow-calf operation and quarter horse operation. And then on my family, my extended family on both sides,
Mhm.
all crop as well. So
Do you feel like that kind of changed the dynamics of heading this or working in this case for you, positively, negatively, however?
oh, sure. Well, I mean, sure. I mean, has, you know, the whole reason that my wife and I wanted to build a practice around helping farmers and ranchers, because that is our background. My wife's from Northwest Missouri, but she grew up between Savannah and King City, and grew up on a cow, calf, and crop operation there, and with her extended family farms as well. And so, for both of us, I mean, this is obviously something we care deeply about, and so I mean, it's the reason we're in this to begin with, in terms of trying to make that a real focus of our practice. But no, I think it definitely helps and makes a difference in terms of working with producers, because you understand, I think, the daily challenges in a way that obviously suburban or urban attorneys don't, or people that don't have an agricultural background.
John isn't just a neighbor, he's a friend. So when he started acting differently and when he wasn't coming to the coffee shop every morning, I knew something was up. The stress of farming is real and affects everyone. So I spoke up and suggested John get help from the Agri-Stress Helpline for Missouri, where trained professionals who understand farming were ready to help. The call was free and confidential, and now he's back at Morning Coffee Talk. Don't wait. Make the call or text 833-897-2474 or find out more on the Missouri Department of Agriculture website.
Let's just kind of wrap it up and talk about, with this victory, what would you say the outlook moving forward is for animal agriculture?
We're such an interesting crossroads in animal agriculture, because on the one hand, the United States is so well positioned to take advantage of growing global demand for meat in a good way. That there's tremendous opportunity here. The question is, are we going to screw that up by regulating ourselves out of that business right as it becomes massively globally profitable, potentially? Because there are cultural challenges, obviously, for livestock operations. You have a small but growing set of, ethically by their own personal ethics, ethically motivated vegetarians and vegans. Deeper than that, you have this drumbeat of the alleged environmental harm of livestock operations, much of which is bunk. I mean, it's like so much of the environmental movement, when you really dig down, it is a economic movement masking itself as a scientific movement, is what it really is. I mean, because anytime you take a solution to them that isn't radically redistributionist, but might fix a problem they allege exists, if somebody's going to get rich fixing the problem they propose exists, suddenly they don't want to fix it that way. I mean, you see it in things as far flung as nuclear power. I mean, nuclear power gives you an amazing amount of green energy that has no emissions. But we don't want to do that. Well, do they not want to do it because of scientific reasons? Well, no, it has nothing to do with science. It has to do with cultural and political perceptions about the way that's tied to the nuclear weapon industry, and the fact that to run a nuclear plant, you have to have relatively large, sophisticated companies, and they might get rich. And it's the same thing here. If you take them sophisticated solutions to what they allege to be environmental harms of livestock, I still don't think they'll get on board. And so it's really an economic movement, socially and politically, more than it is a science movement. But those challenges are out there. We've got to be realistic about those challenges. Now, I think that we're doing a much better job than we did 10 years ago of getting the message out, because we were flat-footed for so long that, that we let them paint this picture of livestock producers as evil, which shocked all of us, right? All of us in rural America, it shocked us because it bore no resemblance to what we know actually happens every day on farms and ranches across this country. But so I don't know. I mean, I guess this is always the way it is with the ag, but I mean, particularly right now at this crossroads for the livestock business, it's just chock full of opportunity and also fraught with peril. And so we've got to stay aggressive in multiple fronts. We've got to keep telling our story on the one hand, because politics is almost always downstream of culture, right? So if you don't talk about the culture, then you don't deal with the problems culturally and socially as they arise, and keep making the philosophical case for what we do. I know that's all, it sounds very high-minded, but I mean, this is as simple as just you continue in your own town, in your own space, and online, all the things we're doing, the things that we've really gotten better at the last 10 or 12 years, to really get out there and tell our story. Like, no, we're not trying to kill you. We really aren't. We're not working our tail off out here, every hip deep in the mud to try to kill you. We are raising a wholesome product that will nourish you. We got to keep telling that story, and we have to keep working on the science side to say, no, this doesn't make sense. This does. We have to keep adopting best practices ourselves and trying to develop best practices that are economically viable where we can, to counter some of that and to stay where we're at. And then we also have to stay really united and active politically. It's just the reality. And so, eternal vigilance is the price of liberty. That's really where we're at, is we have to stay engaged politically. Agriculture is able to punch above its weight because we have been historically well organized and unified in our messaging, as we should be, because we've got a lot of truth to tell the world. We're going to have to keep doing that. And I know it stinks. Nobody likes it. I mean, only a lawyer can love some of these issues, and I don't even like them that much. But we have to do that. I mean, it's what it's always been in American agriculture, and will continue to be. Is that the work we do every day on the farm and ranch is critical, obviously, but at some point we also got to stay engaged. Got to keep talking to elected officials, talking to the American public at large, and stay after it, because that's really a key to our long-term survival. Yeah. Because if we can't go and actually get, we can be as right as we want to be, but if you can't go actually, get good regulations, smart regulations in place and kick the bad ones and the dumb ones, like what we've dealt with here, it doesn't do us a lot of good. And really the leverage obviously here was the legislature. We've worked hard to make sure the legislature understood the issue, and they've given us what we needed in terms of a ban on local authority that was being used abusively.
Absolutely. Thank you.
Thank you.
That was great. Thank you for joining us and just kind of laying it all out for us. With that, thank you all for joining us for another episode of Stand for Ag.
Thank you for joining the Stand for Ag podcast with Missouri Farmers Care. We're excited to bring you new stories each week. We as agriculturalists have a lot of stories to tell. Stories of resilience, grit, and stories of families that are united by their passion for agriculture. Each week, tune in for a new episode and join the conversation.